Hey, yeah, what's poppin', gang? We back. What's good? All right, man, listen, it seems like for a while we had kind of avoided Drake. We did. Like, if you kind of look at some of the streams, we was able to kind of avoid him. I think for maybe like, what was like 3 weeks to like a month, we was kind of able to avoid him since the last Iceman stream, which I believe was like mid-July, I think. I can't remember when it was, but we was able to avoid him. And then it seems like as of recently, there is something new. There's something new almost every day. What up, my boy? What up, Lou? What did I mean? No S. We was able to avoid him, man. We really were. And I kind of liked it that way. I kind of enjoyed it that way. But as you guys know, man, it has been almost every day there has been something new. We've been talking about Drake a lot. And I took your guys' advice. Shout out to Noah, shout out to Tracy, shout out to Hammer, shout out to Terry, shout out to Rocky. Everybody, let me know what's up, man. Let me say where you guys are watching from in the chat, man, and how you guys feel about this case. I feel like I took your guys' advice because I felt like we was getting heavy into the Drake stuff, and I kind of backed off on the Drake stuff. And then now I'm actually seeing too, Jalopy has something to say in reference to a boycott. Which, if you guys are familiar, if you guys have been here for a while, you'll notice and understand. I kind of have been taking that approach already, right? Like if you guys look at some sexy songs for you, there's no reaction on this channel for some sexy songs for you. We reacted to I can't even remember the name of the damn song. The Nokia. We reacted to the Nokia video because there was talks of it having something to do with mocking Kendrick, and we did that. So I've already kind of taken that hit, so I'm cool with taking that hit again. And when I say taking that hit, is the views or whatever that would come from that. I've already seen what it's like to not get that, so I'm cool with not doing that. I will react to that video probably either a little bit later today or tomorrow. We are here extra early today because this is a 53-page transcript. I plan on reading this entire transcript. And kind of not stopping as much, but giving an overall understanding or overall take on what I'm hearing or what I'm seeing in his. And it seems like for the most part, they getting cooked. Okay, cooked is the word of choice. What up, Classy K? Cooked is, they getting flambéed over here. You know what I'm saying? So we definitely gonna go ahead and get into this. There's nothing here that I haven't read any of this. Hey, shout out to Alex. Don't do it. Shout out Alex. Like I said, let me know where you guys are. Let me know where you guys are watching from, and let me know what your take on everything is. This is a discussion, open discussion. I will look over to the comments every now and again just so we can kind of get a understanding of where you guys are, what your guys' take on this. Hammer, where's your wrench? You must be on a different account. All right, listen, here's one thing I'm going to ask of my mods in this chat, right? Here's one thing I'm going to ask upstate New York, Rochester, PA, Florida. One thing I'm going to ask of my mods. I have been noticing an uptick, like probably the most I've seen since we started, reacting. I've been seeing an uptick in trolls. I've been seeing an uptick in Drake Glazers. Now, here's what I'm going to say. In this chat, we can go back and forth. What we will not tolerate is disrespect. Period. Towards me, towards any of the crew members in here. Disrespect, no, there's no chance. Any sign of disrespect, get him out. Period. If you have the capability to do it, get him out. Okay? Nothing towards me, nothing towards anybody in the chat. We can go back and forth. I said it again. We can go back and forth. There's no problem. Disrespect, zero tolerance. We not playing that over here. I've had to ban so many people over the last couple of days because they are disrespectful. We just having a conversation. Okay? All right. Hello. Working and listening to. Thank you. Yeah, got that fire on me. What up? All right, just so you know. All right, let me turn my phone down, bro, because this is going to take a minute. Let me turn my phone down. Listen, hit that like button and subscribe to the channel if you are new, man. If you guys are hitting that like button, it's sending out that beacon and it's letting people know that we're doing something over here that people want to see. So make sure you guys hit that like button. It really helps out the streams a lot. All right. So let's start from the top, man. Wilkie Farr and Gallagher LLP, attorneys for the plaintiff, which is Drake, okay? Michael Gottlieb, Brady Sullivan, Anna Gottfried, okay? That's the Drake side, the plaintiff, okay? Attorneys for the defendant, Rollin Ransom, Nicholas Crowell, Caitlin Everson, and James Horner. Bro, it's crazy. Okay. Anyway, Ransom, Gottlieb are I think the main two that we'll see, and those Sidley Austin LLP, attorneys for the defendant, is UMG. All right. Crew, you covering Chance's album? That is something that we'll get into. We'll get into that probably tomorrow. I think I'll probably actually stream tomorrow because there's a lot to cover. All right. Case is called Mr. Gottlieb, aka Drake side, just so you guys understand it. Mr. Gottlieb, good afternoon, Your Honor. Mike Gottlieb from Wilkie Farr and Gallagher on behalf of the plaintiff. With me at counsel table are Brady Sullivan and Anna Gottfried. Mr. Ransom, UMG, good afternoon, Your Honor. Rollin Ransom from Sidley Austin on behalf of defendant UMG. And with me today from Sidley are Nicholas Crowell, Caitlin Everson, and James Horner. The court, good afternoon, everyone. We are here today to hear oral argument on defendant UMG recordings, motion to dismiss the complaint filed by Aubrey Graham, popularly known as Drake. So let me outline how I'd like to proceed this afternoon. Since this is UMG's motion, they're going to argue first, okay? And then I'll hear from plaintiff's counsel, and then I'll allow UMG to have a rebuttal. So they're going to let UMG go first, then they're going to have a little argument, a little bit of rebuttal, and then they're going to be able to talk about it again. UMG is going to be able to have the last say in that. For the sake of the court reporter, I would appreciate if counsel would speak at the podium today. I don't want to let everyone know that I have reviewed the amended complaint. Wow. I was going to say, wow, I don't want everybody to know. I do want to let everyone know that I have reviewed the amended complaint, the documents that were the subject of the request for judicial notice, and the parties' memorandum of the law. So you should assume in your arguments my familiarity with those materials. So just so you know, I am familiar with what's going on here. So don't assume that I don't know what's going on. Shout out to Alex for the 10. Alex for the 10 says, I handled federal court cases in Florida. This case is running like every other case where one-sided doesn't have the info needed to defend the case. All requests will be objected to. Andy Pandy for the 5. Drake didn't consider that Jude would make him legally declared an idiot. He thought he was legally vindicated even if he lost the battle. Dumb. Thank you for that. Thank you guys for the donations, and I will get to them as soon as I finish the page. I'll get to the donations. Thank you guys so much for that. Okay. Now it begins. Let me get my water ready, bro. To preview for you my specific concerns and what it would be most helpful for the court for you to focus on, there are a few issues that I would predominantly like to hear from the counsel today. The first of those is whether or not I can make a legal determination at this stage in the proceedings as to whether or not the statements challenged as defamatory and Kendrick Lamar's lyrics are fact or opinion. The first of those is whether or not I can make a legal determination whether the statements challenged as defamatory and Kendrick Lamar's lyrics are fact or opinion, okay? So listen, I have to make that decision whether I can make a legal determination whether they're real or if it's just an opinion. Understand me? Second, if it is appropriate for me to resolve that on a motion to dismiss, whether and to what extent I should consider the documents submitted by defendants in their request for judicial notice in making that determination. And finally, applying the New York Steinhilber factors. Oh my God, where are my lawyers? Finally, applying the New York Steinhilber factors are the challenged statements, fact or opinion, with the meaning of New York defamation law and the New York State Constitution. With that preview of the court's particular concerns, counsel, you may proceed. Y'all like how we doing this? Y'all like how we doing this? Mr. Ransom, this is him. Thank you very much for your honor, and thank you for the guidance, which is helpful. I will focus my comments on Drake's defamation claim, although I would like to address the other two claims as well. And I'll focus on our primary argument, which is also the subject of the court's questions, which is that the statements at issue constitute non-actionable opinion rather than statements of facts. Let me read that again. Non-actionable opinion rather than statements of facts. And to frame it, including in light of the court's questions, I want to start with a critical observation, which is that under binding New York law, that issue, the fact versus opinion issue, is a question of law solely for the court. Okay, so it sounds like, let me put my hat on real quick. I want to start with a critical observation, which is that under binding New York law, that issue, the fact versus opinion issue, is a question of law solely for the court, where we want you to determine that. We want you to determine that. It is solely for the court to decide as an issue of law, which we believe makes it particularly suitable for a determination on a motion to dismiss. So basically, you have the ability to do that. You have the ability to do that. We want you to go ahead and dismiss it. You have the ability to do that. And we see, and I will address a number of cases dismissing claims on this basis. So they have proof that there have been cases that have been dismissed that are similar to this, is what it seems like. And it is amazing to me that not once in Drake's 27-page brief does Drake acknowledge that this is, in fact, an issue of law for the court rather than a factual issue to be determined by the jury. Oh, okay. So Drake acknowledged. So in Drake's 27-page brief, does Drake acknowledge that this is in fact an issue of law for the court rather than factual issue to be determined by jury? So basically, he's not saying it's. He doesn't mention that it's a legal issue. He just wants it to be determined whether it's true or false. Okay, we'll continue. Actually, let me get some comments first. The judge seems to borderline. Wait, the judge seems to borderline incompetent. This is going too far. The judge is incompetent? Just think, y'all out tax dollars are going to accommodate a trial over a rap beef. Yes, that is kind of weird. Motions to dismiss are usually not granted. They leave the question of fact up to the jury. Otherwise, it's appealed. That's exactly. Thank you for that, Alex. That's what I was saying. Motions to dismiss are usually not granted. They leave the question of fact up to the jury. So for the jury to decide if it's fact or opinion, as they stated here. Trying to win a rap battle in the court. Facts. No, the judge is doing his or her job. Please read the documents. Right. I don't know. Somebody said the judge is incompetent, so I kind of wanted to bring it up. Are you going to review Chance's new album as a Chicago native? Black Healer, you know we're going to do that, man. We'll continue. We are currently on page 4 for anybody who's following. We're currently on page 4. The court. Well, let me stop you there, because you are correct that there are a number of cases where courts have decided this on a motion to dismiss. The New York Court of Appeals in Bryan is one such case. But then, subsequently, following Bryan, New York Court of Appeals had Davis v. Boeheim, which was in the context of a motion to dismiss and relied quite heavily on the early procedural posture of that case in finding or holding that the standard that applied at a motion to dismiss stage was whether or not the communications taken in their ordinary meaning and context are susceptible to a defamatory connotation, and suggested that if they were, and that if they could be taken in such a light, the motion to dismiss should not be granted and discovery should proceed, which strikes me as being somewhat in tension with the court's prior decision in Bryan. So basically, she's saying that she's in contention with this, right? Like, so there have been times where they were able to dismiss. But then there's also a time where she's saying, and if they could be taken in such a light, then the motion to dismiss should not be granted and discovery should be allowed to proceed. So it seems like there was a case where it was allowed, where they could just dismiss, and then there was a case where it was not. So that's why she says she's in contention with Bryan, which, as you have observed in your brief, did permit a motion to dismiss because it is an objective standard. It's a reasonable listener standard, a question of law, and applied a somewhat different articulation of the test as to would the reasonable listener have understood the allegedly defamatory comment as opinion versus fact. If I'm honest, I still don't understand how that's possible. I still don't understand how you could tell what a reasonable listener would understand. I mean, the jury has to be such. I'm speaking out of my mind. I don't know. So if I'm speaking, if there's a jury involved, I guess there has to be like a super diverse jury to be able to do that. Unless they're saying there's not a jury and it's just left up to her to determine that. I don't understand how they would do that. Thank you for the 5. Chaos Forever. Lawbre's Lawyers here. You're next on our court list, along with Screwface and all reactors. You bunch of criminals. Shout out to you, man. I appreciate you. Okay, next page. Let me just find it. Okay. Hoodie for the 2. When Drake signed that 400 mil, it was raps. You already know. From the op list to the cop list. Shout out to Screw. So I would like you to address that tension between those two cases. How do I reconcile them when I have to apply New York law? So are those cases that they're referencing not New York cases? Because it seems like, yeah, that worked over there, but I don't think that'll work over here. That's kind of what I want to understand. Mr. Ransom, of course, Your Honor, 2 things about Davis versus Boheme. The first, including the way the court characterized it. The issue of whether a particular statement is susceptible to a defamatory connotation is a distinct element of the defamation claim from the question of whether it's a fact or opinion. And I recognize that on that issue, whether a statement is susceptible to a defamatory connotation, there are cases that suggest that there's a dispute as to whether statements could have a defamatory connotation or not, might go to the jury. Oh, that is treated distinctly from fact versus opinion. And in fact, we see that distinction in Goldfarb, the case that Drake primarily relies upon, and which, as we pointed out in our reply, they misapprehend on this point because the court considers separately and distinctly the question of defamatory connotation on the one hand, and a fact versus opinion on the other. And fact versus opinion on the other. And as to fact versus opinion, the court expressly notes that this is a pure question of law. Oh, okay. I see what they're saying, bro. It's a pure question of the law. Okay. Fact versus opinion. That's it. It's real simple. Fact versus opinion. Shout out to Chaos Forever again. All Aubrey missing is I ain't even. Thank you for the 2. The court. That is true. But I do want to press back on your reading of Davis, because Davis also does consider the opinion versus fact distinction and says that they cannot state as a matter of law that the statements are pure opinion, because there's a reasonable view of the claims that have been asserted in the complaint. So they're saying, it sounds like they're saying in that previous case, they can't state that it's a matter of law because the statements, that the statements are pure opinion because there's a reasonable view of the claims. So there's a reasonable way to look at whatever the claims were, in the same way that there's a reasonable view to view Drake as a PDF. Even if we're talking about the stage incident, you could consider that too. You feel me? You could there's a reasonable reason to believe that opinion because we've seen that before. See what I'm saying? See what I'm saying? Where am I? And that the court has to take that reasonable view in light of in favor of the plaintiff at the motion to dismiss stage, and therefore decides not to dismiss it. So they're saying that it's kind of working against them. It's kind of working against them that there is kind of this in the air kind of context that Kendrick was playing on, knowing that that shit is out there and people are looking at it like, well, we could kind of believe this because there's already some shit out there when we seen it already. Kind of makes sense. So although, yes, they also discussed the defamatory context, there is a portion of that opinion that is focused on the opinion versus the fact distinction, which is the one raised by the defendants in this motion. Mr. Ransom, this is UMG. And I do think that, in that respect, there's a slight conflation even in Davis. That said, Davis continues to apply the Steinhilber test. I need to look up this Steinhilber test, including the consideration of the four sometimes collapse as three elements of determining fact versus opinion. Yo, what is the Steinhilber test, bro? Hold up. Oh, it is not easy. It is not some easy thing to look at. The Steinhilber test. Oh man, where my lawyers at? Where my lawyers at? Somebody let me know what the Steinhilber test is. I would love to understand what they're using to determine, what is fact versus opinion. Somebody let me know. And I think what's ultimately critical about Davis, and I think what's ultimately critical about Davis gets to the court's final question of those that it laid out, which is this fact versus opinion? And what was critical in Davis was the court's ultimate conclusion that the nature of the statements in Davis strongly suggested that the speaker had undisclosed information underlying his statements that would lead a person to conclude that the statements were fact. Ooh, let me go back to that again. And what was critical in Davis was the court's ultimate conclusion that the nature of the statements in Davis strongly suggested that the speaker had undisclosed information. So that's also kind of similar to the Kendrick situation, where it did seem like Kendrick said, I had 5 more in stock. I know shit about niggas that make Gunna Wanna look like a saint. And I think those are things that have been brought forth too, where it seems like we know more, we just haven't said anything, or at least we have a basis to pull from while we're making the statements that we're making. I heard Ja Rule and MGK are gonna sue Slim next. They are. Shout out to Chaos, live, love from Portugal. What up, Portugal? What up, Chalupa? And as you walk through the ultimate conclusion of Davis in determining that it survived a motion to dismiss on the fact versus opinion issue, it was ultimately driven, I submit, in its entirety by the court's conclusion that there were multiple factors that would lead a listener to believe that the speaker there had undisclosed information unique to him that led him to make the statements that he did. They included reference to the fact that there was an investigation at the university underlying his conclusion that his statements came out before the results of that investigation were released. That he had held a position of authority at the university about which he could speak with authority and solemnity. And that the nature of his comments presented for an article and discourse on the issue were such that they were not rhetorical hyperbole. They were not in extremis or other consequence that led to conclude that they are likely to be statements of opinion. So that was the ultimate conclusion reached by the court. And we have none of that here. None of the context, none of the indicia, hopefully I said that right, that suggests a thoughtful statement of fact based upon some weighty investigation as to which the speaker is privileged. So they're saying, I thought they were saying we do kind of have some of that similarity, but then the judge is saying we don't have any of that here. We don't have any of that. They're saying we don't have any of the same factors that they had in that case to make that same motion to dismiss possible here. So it seems like it seems like they're still going forward with this, right? Hey, yo, what up, Aaron? And I'll address that in greater detail. But I think it's critical, even under Davis, which continues to articulate and apply the Steinhilber factors, to emphasize that context is key. In Steinhilber, here are the words: even apparent statements of fact may assume the characteristic of statements of opinion when made in public debate. So, okay, even apparent statements of fact may assume the characteristics of statements of opinion. So even facts could look like opinion in public debate. Heated labor dispute or circumstances in which an audience may anticipate the use of epithets. Excuse me, guys. Fiery rhetoric or hyperbole. Steinhilber was 40 years before its time. Epithets, fiery rhetoric, or hyperbole, it might as well have been said statements in a rap battle. Basically, I was going to say, bro, it might as well have been said it's a rap battle. They was way ahead of their time. They laid the groundwork for this case. Basically, caught my first live. What up, Kamika? Let me know if this is your first live too, and if you're new here. 500 people watching, 120 likes. Run it up if you guys don't mind doubling that. Did I miss any donos? Yeah, but if Lawbury wins this crap, Ja, MGK, and others will have precedent to sue. For first live, what up, Thalia? Okay, let's get back into it. And even Steinhilber and the subsequent cases, including Davis, and as exemplified in Davis, recognize that the contextual assessment of the context in which the statements are made often, ultimately, determines whether one would perceive these as facts versus opinion. And that's what was found in Davis because of the context in which those statements were made. And on the other hand, in Steinhilber, because of the context, the statements were made in Steinhilber, the court affirmed a motion to dismiss, dismissing the complaint as a matter of law, concluding that although the statements may be perceived as factual, the context in which they were made would lead a reasonable observer to conclude that they were pure opinion, including because of the heated nature of the communication. So then, by saying that, it kind of goes back to they did that because a reasonable observer could conclude that they were pure opinion, including because of the heated nature of the communication. This was a heated battle. So I think most people just assumed that it was all opinion and it was all hyperbole. I don't think anyone really thought it was fact. Air quotes, air quotes. They're probably watching all of these videos too. They probably all of these videos. You gonna react to Chance? Bro, we are. We're gonna react to Chance too. I see a lot of people are looking forward to that. We're gonna react to Chance, but we're probably not gonna do it today. We'll probably do it tomorrow. The court, since you bring up context, isn't the logical import of your argument that the statements made in either a rap battle or diss track therefore are categorically opinion? So this is the court responding to Ransom, which is UMG. Isn't that the logical conclusion of what you're saying? And is that a fair reading of New York's case law that where the New York courts have said form is not necessarily dispositive? But it does seem to me that you are arguing that form here is dispositive. A rap diss track just can't be taken as fact. Mr. Ransom, UMG. Your Honor, the cases that say form is not dispositive, I don't dispute that proposition as a general proposition. It's typically raised in context, for example, of an op-ed page or a letter to the editor where the context would tend to suggest one of opinion. But the courts say it's not dispositive. And I suppose in those circumstances that it's theoretically possible that the nature of the communication, even in what is otherwise thought to be an advocacy piece with heated rhetoric, may support a finding of fact versus opinion. So it seems like they're kind of agreeing and saying, I could see how in these situations, theoretically, you could take it as fact versus opinion, right? Whether a diss track in a rap battle could ever cross the line from opinion into fact is an interesting question. Question for y'all. Anybody watching on the playback, if you made it to about 30 minutes in. Whether a diss track in a rap battle could ever cross the line from opinion into fact is an interesting question. I definitely think you can. Personally, I think diss tracks can definitely go from opinion into fact. I think there's a little bit of fact in all of these disses. I don't think they're all just lies. I think it's built on kind of the backbone of there being a little bit of extra sauce, pause. But I don't think it's just all lies. Chaos Forever for the 5. I appreciate you. We appreciate your takes and breakdowns, brother. Like and subscribe, people. Thank you. Like and hit that sub button. I would submit that the nature of the art is that is at most highly unlikely and may categorically be the case that it doesn't. But what we're dealing with are the facts in the case here. And what we can see and what we can look at on the facts here is that the nature of the lyrics clearly convey the sort of rhetorical hyperbole, over-the-top trash-talking extremists that, using the language of the court appeal in New York and federal courts applying it here in the Southern District of New York, are clear. And we submit dispositive indicia. Pause. Indicia. A rhetorical hyperbole and opinion rather than fact. And you can see that more pointedly in cases that are closer to this than those that offer the reservation about the form in which the statement is made. Shout out to Leonardo for the dub. I appreciate you, man. No dry snitching. I might be wrong, but I'm surprised that EP hasn't been mentioned whatsoever in any other paperwork. Likes up, y'all. Hit that like button. I appreciate you, man. What up, Deontay? So, in Hobbs versus Imus, for example, again, affirming the grant of a motion to dismiss the court relies on the fact that these are shock jocks, ladies and gentlemen. They're all extremists, okay? So they're painting a picture of this is just what they do. This is the way it's done, okay? And it's not just the limited statement in which the alleged defamatory communications are made. The court relies upon their notorious history and their nature of shock jock journalism from these speakers in particular as supporting its conclusion. On a motion to dismiss, that the context tells you that these are statements of opinion. And it acknowledges that if you just look at the statements taken in isolation, one could argue that they have the
Indicia. All
right. I just want to make sure I'm saying this right. Shock jock journalism from these speakers in particular are as supporting its conclusion on a motion to dismiss that the context tells you that these are statements of opinion. And it acknowledges that if you just look at this statement taken in isolation, one could argue that they have the indicia of fact. But when you look at the shock jock context, the court ultimately concludes the claim must be dismissed. Shout out to Deontay for the 2. Next, Drake gonna put Crew in a lawsuit. I hope not, bro. I hope not, man. I hope not. In Rappaport, the court, again, let me press you on this. So it seems like, it don't seem like it's just one-sided. It seemed like, well, I don't think the other side has spoken yet. I don't think Gottlieb has spoken yet. They're really pressing them to prove maybe why they can't dismiss at this point. Again, let me press you on this. The context here is the rap diss battle, and we're here on a motion to dismiss. When I'm considering that context, don't I need to know more about whether the ordinary listener of, and maybe this is worded weirdly, I'm sorry. Don't I need to know more about whether the ordinary listener of, and maybe there's a question, as to who the ordinary listener. Is it someone who doesn't follow rap music and is just hearing it on the radio? My question to that would be, if you don't listen to rap music, they do not play rap music on Q101. They do not play rap music on country stations. So if you hear it on the radio, you're probably tuned into a rap station, which would mean that you currently listen to rap music. I don't know. Maybe I'm just making it up. Feel me? Is it someone who actually is it someone who's actually immersed in the community and that type of music and has that background? Those questions that we could also discuss. Those are questions that we can also discuss. But with respect to the context on a motion to dismiss, how can I say that the ordinary listener would comparing this now to the shock jocks, I think, or shock jobs, I don't know. Shock jobs say shocking things. How do I, sitting here as a judge, know that the ordinary listener of a rap diss track would also have that same underlying assumption? I think that's kind of weird though. That part right there, if you listen to rap regularly, it would almost seem that you would understand the basic logic behind rap and what it is. Not to say that you are a historian and completely understand everything about it, but you at least have a general knowledge in a sense. Isn't it true, for example, that sometimes accusations are made in rap battles that are true and turned out to be true? And maybe listeners have that understanding. And sitting here as a matter of law, can I say that they would not? Do I need to have more discovery, potentially experts, potentially more context for this particular rap battle or rap battles writ large before I can make a judgment as a matter of law? Mr. Ransom, UMG. There's no suggestion in any of these cases that this is a subject of, for example, expert testimony or otherwise. So they're saying, bro, listen, there's no suggestion in any of these cases that we're presenting any of these people to be experts, okay? What the court is required to do under the standard, as articulated in both the New York State and federal cases, is to look at the material before it and reach that determination based on its evaluation of the statements and the surrounding context. And we can again look to an example in Terrain v. Liu. And Terrain v. Liu again resolved on a motion to dismiss. The court did take into account the context, and I do want to address the court's question about whether it can look at this material at this stage, because I think Terrain is particularly probative of that point. But the court looks at the information and makes an assessment on its own. It did the same thing in Rappaport. Now, admittedly, Rappaport was a summary judgment motion, but it illustrates the nature of the information the court is to consider in reaching that determination, which is the language used and the broader context in which it is provided, that the universe of the material it looks at. That's the universe of material it looks at, and then it comes to a judgment. The court. But if the broader context, which is what we're talking about, is perhaps a specialized world, then perhaps the court does need more information. So basically, she's like, but if it's not this broad thing and it's a specialized world like rap is, then perhaps the court does need more information than is in the four corners of the complaint. And even in the request for judicial notice, to understand that context and correctly apply the legal tests. Do I have enough facts about that broader context to come to a decision about what a reasonable listener would conclude, whether or not the statements made in the song are to be taken as fact or opinion? So I guess my question would be, now, here's the thing. Here's an honest question. I don't know. Can a judge take into consideration their own experience? Right? Like, can a judge say, I'm an avid listener of rap, so I understand this better? Or, you know what I'm saying? Or do they have to specifically go on what's being presented to them? Shout out to Chaos Forever again for the 5, gang. Thank you so much. Y'all running it up today, man. The judge is covering all the angles as he knows how important this is to make precedents. Oh, thank you. Okay, so it's covering all the angles from opposition to what they would say, because that's kind of what I was thinking. Is it seems like they're attacking everything they say from their standpoint so we can establish kind of a roadmap to how we're going to answer all of these questions later. Maybe, right? Okay. Mr. Ransom, Your Honor, again, what the cases do is look strictly at the material that is presented, including the context that's provided. You do have additional information, certainly, in the form of amicus brief that was provided in support of our motion, but also from the complaint itself. And what is interesting and notable in this case is that the complaint not only includes the allegations, but it cites and references the fact of the rap battle. Articles describing the rap battle, articles describing the context of the rap battle, and the history between these particular artists, including the rumors. Including the rumors, innuendo, and controversies that have surrounded Drake with respect to his relations with underage women for an extended period of time. The context is provided there. Oh my God. There's no suggestion in the case law that the court needs to limit itself to a particular type of individual, a particular type of listener, or that every listener has perfect knowledge of all the information surrounding it. Now they heating up. That would turn an objective test into a subjective test that's dependent on individual particular listeners with very specific information. And none of these cases suggest that it is required. In fact, all of the cases that talk about this issue posit that the information is generally available and considers with that information that is available, what would the objective listener reasonably understand? Okay? And on the question of what the court may consider and evaluate again, we look, there's some spelling errors here. We look at terrain in particular. Here's a case where the speaker made a statement and the plaintiff disputed whether or not the court could consider surrounding context, including earlier statements by the plaintiff that prompted the defendant to make the challenged remarks. In footnote 1 of the circuit opinion, it's also in footnote 1 of the district of court opinion. The court says, let me get a sip. Let me get a sip. Let me get a sip. Terrain, the plaintiff, contends the district court improperly considered the statements that he made during his war of words because they were not included in his complaint. That argument fails. As noted above, in determining whether a statement is actionable, the court should look to the overall context in which the assertions were made and determine on that basis whether the reasonable listener would have believed that the challenged statements were conveying facts about the libeled plaintiff. Terrain himself introduced this context in his complaint, noting that he was engaged in a war of words with the rival disc jockey. That's exactly what we have here. Drake's complaint identifies the rap beef, identifies a number of tracks in the rap beef, and then cites countless articles describing and discussing the rap beef and all of its context, and all of it properly before the court and may properly be considered by the court in connection with a motion to dismiss. And I think what's critical is that it includes, for example, Drake's own statements in the tailor-made freestyle. We're forgetting the tailor-made freestyle. How did Drake just forget the tailor-made freestyle, bro? Literally trying to act like the tailor-made freestyle never happened. Bro said we fed you the information. Give him information about a daughter. I bet he takes it. God, bro. All right, let's keep going. In which he specifically said and prompted to Kendrick Lamar, referring to himself in the third person, talk about him liking young girls. That's a gift from me. Why are we here? Why are we here? So when Kendrick Lamar then raps, "Hey Drake, I hear you like him young," there's no secret. He brought it up. Or surprise or mystery of the context in which that statement is made. Again, these lyrics, this context is all properly before the court, including because of the way the complaint is pled and the abundant references not only to the lyrics themselves and the beef itself, but also to articles that provide the context to the court that allows it to make the determination that it needs to make, which is they believe it needs to be dismissed. I'd like to briefly address what seems to be the primary argument that was raised by Drake. Although I think not necessarily specifically raised by the court, but in the event there's a question, there is heavy reliance on the online statements made after Not Like Us came out, which Drake says suggests that members of the public believed that these were statements of fact rather than opinion. And this argument is wrong for so many reasons. It misstates the standards. It misstates the standard because, again, you don't look at the subjective views of individuals. It is an objective test based upon the reasonable listener. So it doesn't matter what 10 or 20 or 40 or 60 people say, because that just reflects subjective views. Subjective views. Let me say that again. Subjective views. And that's even before you get to the substance of the reviews, which themselves reflect this rhetorical hyperbole, not to mention emojis and misspellings, profanity, and even racism and anti-Semitic remarks. Nothing of that informs the objective standard the court is to apply. Okay? Second, it ignores the fact that this exact same argument was raised and rejected in Rappaport, directly at the district court where evidence was submitted of all of these statements of people after the diss track was released by Barstool, challenging Rappaport. And Rappaport argued this shows that people thought it was fact. And the court rejected that argument. And the Second Circuit affirmed. And it ignores Drake's own statement. Drake's own statement, which we've attached as Exhibit A to the request for judicial notice, about the pernicious danger of relying on statements in rap tracks and rap lyrics as truth, as evidence of truth, as statements of fact about the chilling impact on this art form and the chilling impact on artists. And I don't think that can be overlooked. Drake himself took the position that you shouldn't do exactly what he's asking you to do right now. He was right then, and he is wrong now. Finally, on defamation, Drake has also argued that this is somehow mixed opinion, suggesting that somehow Kendrick Lamar is uniquely and privately privy to undisclosed facts about Drake's sexual proclivities. Oh! Oh! Down bad, you suffering. Down bad, you suffering. I think just to say it refutes it, but again, Drake himself goaded Kendrick with talk about him liking young girls. That's a gift from me. And Kendrick says, "Hey, I hear you like him young," and goes from there and not like us. No suggestion of some hidden secret information. But in any event, this is also an issue of law for the court. Whew! 17 pages in. I didn't even think we was that far. Yikes. I didn't even think we was that far. Any comments? Like the video if you think this lawsuit is goofy. Facts, 725 watching, 240 likes. Let's get it to like 350, 400. Why is Drake trying to prove things when Kendrick isn't? I guess he cares what people say. Good Lord, how many pages? Oh, we gonna get through this. We powering through. Hit that like button. Let me know what you guys think about the case as we go along. I will definitely stop and look at some of the comments if I can. Shout out to all of the new subscribers. I appreciate that love and support. I heard Meet the Grams in a mall today. By the way, just a side note, I was legitimately concerned what they doing. No way. Many pages. Buckle up. Let's get back into it. No time to waste. Now we're hearing from the court. But there are lyrics that tend to suggest, as plaintiff points out, that there is information that Mr. Lamar is privy to. The reference to the rabbit holes and other truths that he can tell that one potentially could read as suggesting that either his statements regarding Drake are based on undisclosed information or that potentially there are other secrets that he has not revealed. So I kind of see now that the judge is really, like we said earlier, I don't think there's like a form of agreement or anything like that, but I think it's basically like, these are the things that the other side is thinking and gonna say. So we have to establish that we're going to attack these points a little bit later, right? There's some ambiguity, there's some ambiguity there, but on a motion to dismiss, I have to read the ambiguity potentially in favor of the plaintiff, Mr. Ransom. And again, the case law makes clear that that is also an issue of law for the court, and that the court is to consider context in that specific circumstance as well. We see that in Cooper v. Templeton and in Steinhilber itself, where the court says, in evaluating this question of whether there are undisclosed facts, the court must consider the context. And so, for example, in Woodridge, the court says, although some of the statements are based on undisclosed, unfavorable facts known to the writer, the disgruntled tone and anonymous posting, among the other things, point to opinion, and ultimately concludes opinion rather than fact. We also see the same thing in Terrain, which, although it suggested some unknown fact, the court said, look, I look at the context as a whole, and this heated public statement tells me that. notwithstanding this trash talking, including about putative, undisclosed facts, ultimately is one of opinion. So yes, when Kendrick refers to a rabbit hole, that is part of the rhetorical hyperbole throughout Not Like Us. And the court must consider that context is evaluating that as well. It's the same way when Drake threatens that Kendrick's darkest secrets are coming to light. I love this lawyer, bro. Or that Drake dug up bones in an excavation. Come on, bro. You did the same thing. That context is part of the nature of the rap battle, and we see that in the amicus brief as well. It does not save Drake's claim here. Okay? Let me challenge you on one specific lyric from Not Like Us, and that's certified lover boy, certified PDFs. It does suggest particularly the use of the word certified. Again, an ambiguous term, but paired as it is with certified PDF, it could give the listener, a reasonable listener, the impression that in some way there's been some determination that in some unspecified official way that Drake is a PDF. What is your response to that? My response is, he said, talk about him liking young girls. Now, I guess the question would be, how young, sir? Right? But I see what we're doing here. Mr. Ransom, UMG. So, two things about that. First is, I think it's critical in considering that particular passage to pair it with what precedes it, which the court quoted certified lover boy, certified PDF, referring to Drake and his crew. The certified lover boy is the name of Drake's album, and so it is clearly and deliberately a play on those words. You ain't slick. Y'all ain't slick. And any more than the certification of Loverboy's status has meaning. The reference to certified PDF is more of the rhetorical hyperbole that we see in this precise context. It also can't. Okay? Shout out to Chaos again for the 2. Say it. The court. This does bring me back a little bit to my prior question, though, which is, who is the ordinary listener? Is it someone who's going to catch all of those references and all of these nuances between these two artists and the community writ large, so that they're going to understand that Drake has a prior album called Certified Lover Boy, and this is a play on those words? Or is it the ordinary listener who may not listen to either of these artists with any regularity and may not have that familiarity? Who is the ordinary listener? And how do I apply that test when there's so much specialized and nuance to a lot of these lyrics? That does require in-depth analysis to catch all of those references. Point to the streamers and the reactors who tell you what's going on. My bad. Don't add us. Because we was definitely telling y'all what was going on for those people who are not casual listeners. See how we're good for the community? Right? Mind you, he also called himself the certified boogeyman. He did, which is he somehow what is it? A fantastic figure who shows up when you say his name 5 times? Mr. Ransom. So 2 things, Your Honor. One, on that question, all of the cases, at least in the way they apply the law, consider the entirety of the context. So again, UMG is looking at this as from a much bigger picture. And when they hone in specifically on lyrics, Drake's side, when they specifically on lyrics, is where they lose the argument on UMG side, because they've done the same thing. When we hone in on those lyrics from Drake, you're doing the same thing. So again, answer the poll and let me know what y'all are thinking. Crew getting added in the next paperwork. Not at all. Hey, little old me, little old 40K, 39. They don't slice and dice it down to what a particular listener of all the context may know and whether every listener knows every piece. In every one of these cases, what the court looks at is the context as a whole, not slice and dice down to individual listeners or assuming that it is limited to just people who actually have specific knowledge of particular pieces of this. I love the way they said that. It's a broader look, bro. We don't got to get down to the nitty-gritty on everything. The other comment I would make with respect to the concerns regarding nuance, or will someone get that, is that there is a danger to that approach that is at least warned in Bryan v. Richardson and also in Mann v. Abel, another New York Court of Appeal case about sifting through communication and picking particular words or phrases out and considering them in isolation. And what Bryan v. Richardson says is that it is dangerous to do because rather than sifting through a communication for the purpose of isolating and identifying assertions of fact, the court should look to the overall context in which the assertions were made and determine on that basis whether the reasonable reader would have believed that the speaker was conveying statements of fact. We see the same thing in Mann v. Abel, another New York Court of Appeal case, although one could sift through the article and argue that false factual assertions were made by the author, viewing the content of the article as a whole, as we must. It was protected opinion, and in that case also the claim was rejected. So the notion of trying to look at a particular phrase, tease it out, and not take into account the broader context of Not Like Us as a whole. Hey, Drake, I hear you like him young, and Drake's statement, talk about him liking young girls. And then the broader context of all the rumors and innuendos and controversy surrounding Drake, young women and girls, I believe misses the thrust of the cases that drive the court's decision, particularly Bryan and Mann. Back to the court. The court speaks. The court speaks. This brings me to my second question, which is the question for judicial notice, because the rumors, innuendo, etc. are not set forth in the four corners of the complaint, except perhaps in some of the exchanges in the song lyrics. But obviously, the defendants have submitted articles that it wants the court to take judicial notice of that allude to those rumors. And presumably, for the purpose under Rule 201, it's not necessarily for the truth of those rumors, but that those rumors existed and were present in the world. Back to Mr. Ransom, aka UMG. That is correct. That is correct. It is not for the truth of the rumors. It is for the fact of their existence. Ooh. It is not for the truth of the rumors. It is for the fact of their existence and the context that it provides with respect to the statements in Not Like Us. But as to whether the court can take judicial notice, the answer is, in that respect, certainly. News articles well within the scope of the judicial notice as are song lyrics. And that is particularly true here because of the articles that we are citing and referencing from Drake's complaint. They are referenced in, citing in, and some of them discussed in Drake's complaint. Now, not necessarily the rumors portion, but the specific articles themselves are from Drake's complaint. And we cite them, just as Drake did. And in our brief, we identify, and in our request for judicial notice, we identify where from the complaint they arise. Excuse me on that. So this is not a scenario where we are going out to finding third-party material that has not already been brought into this case by Drake in his own pleading. On the contrary, when it comes to the question of rumors and the facts and the facts giving rise to the statements that are at issue here, those are included in articles that Drake himself cites and relies upon in this complaint. So we believe the court could properly take into account news articles under the standard RJN, request for judicial notice standard. But particularly in this case, where they are referenced in the complaint and cited in the complaint and relied upon by Drake, we think it's particularly appropriate and the court is well within its authority to do so. And given the requirement that the court consider context, we think respectfully that the court is obligated to do so, because that context has actually been provided, not just by us, but by Drake in his own complaint. Thank you, Leonardo Thomas, for the $20 donation. Judge, if a man that ups the score with they claims to be the certified boogeyman, I'm sure in Discovery there's an explanation of that as a certified PDF. Judges and courtroom bombastic side eyes. Shout out to Leonardo for the $20 donation. I appreciate you. Thank you so much. Thank you so much. Thank you for supporting the channel. I appreciate you. The court, you said you also wanted to address the other causes of action. Let me give you a few minutes in which to do so. Okay, Mr. Ransom. Thank you, Your Honor. I will be brief. We obviously briefed our challenges, and there are many to both Section 349 claim and the Penal Code claim. On the 349 claim, we believe that both parties' cases reflect that the information and belief form of pleading that Drake is using is improper, and that's a sufficient basis alone. But I think what's been made clear from the briefing is where that claim also and clearly fails is on the injury element. The New York Court of Appeal has clearly held the standing under 349 requires a direct rather than derivative injury. You can't have the series of steps between the alleged consumer deception and the claimed harm to Drake, and that's exactly what we have here. So many steps between the alleged consumer deception through artificially increasing the numbers of streams and any impact on Drake under City of New York v. Smokes Spirits in the Court of Appeal, the New York Court of Appeal, and Zilla's, the Second Circuit, that claim clearly fails. On the Penal Code claim, we have multiple arguments, but I think the easiest and first argument is there's simply no private right of action. All of these cases that Drake cites don't grapple with the she-he or she-hi standard from the New York Court of Appeal, which is then re-articulated in Ortiz. And the existence of criminal enforcement mechanisms for that claim really eliminates the prospect of a private right of action. The cases we cite acknowledge the binding she-he or she-hi Ortiz standard. The case that Drake cites largely don't, and in fact are based on authority that predates that binding New York Court of Appeals authority. So we think both 349 and Penal Code claims should be dismissed as well. The court. Thank you very much, Mr. Ransom. Mr. Ransom. Thank you, the court. I'll give you an opportunity to argue and rebuttal at the end. Let me hear now from plaintiff's counsel. Mr. Gottlieb. Mr. Gottlieb, aka Drake. Are you going to be presenting an argument on behalf of the plaintiff? Mr. Gottlieb. Yes, Your Honor. It's about to get messy. It's about to get messy. Some of these comments before we dive in, some of these comments. We only an hour in? Oh man, I thought we was like 2 hours in. We only an hour in. I could have breakfast on stream with y'all. You gotta run. I love this crew. I'll be back for more shenanigans. Oh, shout out to Lost in Translation. Thank you. Shout out to NTG Noah. I appreciate you. It means just that. Documents. It means just that. Documents and communication. LOL. It isn't a DNA test. DNA was never mentioned. He cannot demand one. Burrito stream? Oh, don't make me. Don't make me order a burrito. Because we used to do burrito streams back in the day. Okay. Let's get into it. Your Honor, I like to start, if I could, with a discussion about the appropriate standard of review, because I think it cuts across all of UNG's arguments in this case. And it's important to have a reminder, both from federal standard and the state standard, of why we're here today. Under binding Second Circuit authority, the global network communications case that we cite in our papers, a complaint may not be dismissed pursuant to Rule 12b-6 unless it appears beyond doubt, even when the complaint is liberally construed, that the plaintiff can prove no set of facts in support of his claims which would entitle him to relief. Davis v. Boehm is the only opinion doctrine case cited by either the parties in this case that remotely touches on the appropriate standard of review at the pleading context for evaluating an opinion defense. And it is utterly devastating to UMG's entire argument in this case. As we explain on pages 1 and 7 of our brief, the question on a Rule 12 motion when considering an opinion doctrine defense is not what this court thinks or what Mr. Ransom thinks a reasonable listener should have concluded when it heard the lyrics in question. The question is whether a reasonable listener could have concluded that the statements were conveying facts about the plaintiff. Davis v. Boehm is the controlling authority. There's no other case that either party cited that even purports to interpret the standard at the pleading stage. They think they cooking right now too. I see some of the lags. Oh, let me close out of this. Maybe that's why. My bad. I see some of the lag, but it's okay. As long as y'all can still hear me. At page 268 of the opinion, the Davis court explained that at the pleading stage, we limit our inquiry to the legal sufficiency of plaintiff's claims without evaluating the sufficiency of those parties. Evidence, as would happen at the summary judgment phase, Davis expressly argued in this case that the court should reject the plaintiff's interpretation that were contained in the allegations in the complaint, and instead hold, using the objective standard, which we don't dispute applies, that the reasonable reader would be likely to interpret that this statement as pure opinion. The court rejects that. The court rejects that, and this is the most important part of the opinion. The court says, on a motion to dismiss, we consider whether any reading of the complaint supports the defamation claim. Thus, although, where am I at? My bad. Thus, although it may well be at the challenge statements are subject to defendant's interpretation, the motion to dismiss must be denied if the communication at issue, taking the words in the ordinary meaning and context, is also susceptible to a defamatory connotation. Meaning, if it's susceptible to a connotation that it's fact, and it's susceptible to a connotation that it's opinion, the plaintiff wins at the motion to dismiss stage. Comments, my bad. Shout out to Chaos Forever for the 5. Lawbury needs your DNA to make sure you're not the father. Chill. Oh my God. Okay. The court. As I asked Mr. Ransom earlier, though, how do I square that with the other court of appeals decisions, including Bryan, which was also a motion to dismiss decision? in which they do not purport to overrule, so therefore remains good law. Still cited by New York's courts, but did not use this could standard, did not say is susceptible to defamatory connotation, but says instead, the question is whether or not it would be understood by a listener as opinion or fact presents it as a question of law. Mr. Gottlieb, so your honor, the court, I take you, they cut him off. Wait, did they cut him off? Hold on. So your honor, the court, I take you that Davis definitely throws a wrench in the argument, but there seems to be some tension. How do I reconcile the tension? So your honor, hey, shut up. I'm talking here. Hey, yo, okay. Mr. Gottlieb. So your honor, I don't think there's a tension. So first of all, Davis is the subsequent and most recent opinion, so it would be controlling for this purpose. The Bryan court doesn't purport to interpret the pleading standard. So there's no dispute between the parties as to what the court's inquiry ought to be in evaluating the pleadings in this is one point, excuse me. The second is there's no discussion or suggestion in Davis, the Bryan opinion, anywhere that there was a challenge to the actual content of the allegation in the complaint, which is what we had in Davis. And it is what we have here, where you have the defendants essentially saying, don't credit or believe or draw inferences from the allegations in the complaint in the plaintiff's favor. Instead, accept this other evidence that we're presenting to you and draw inferences in order to determine what the appropriate social context is so you can make your decision as a matter of law. In Bryan, the only thing that the court considers, at least from what one can tell from reading the opinion, is the four corners of the op-ed that was being considered. The court was merely analyzing an op-ed and talking generally about what op-eds are. There's no suggestion in Bryan that there is an attempt to insert extrinsic evidence into the record. There's no suggestion that there was any challenge to the inferences that the plaintiff was being asked to draw of the complaint. And the Bryan court makes clear that in the text of the article itself, the author made clear that the purpose of the article was to advocate for an independent investigation, and in support of the argument, the defendant marshaled all of the relevant materials included within the text of the article. So the court had basically everything it needed in order to analyze both whether it was capable of the defamatory meaning, whether it could be proven true or false, and what the context immediately of the article in the broader social context were. There simply is no indication that there was any dispute before the court as to any of that. In this case, what we have, by contrast, is an express request for the judicial notice that I want to address before I get into the sufficiency of our allegations, if I could. That request for judicial notice asked the court to accept 17 exhibits into the record and to use evidence contained in the exhibit to draw inferences that directly attack, contradict, or undermine the allegations in Drake's complaint. Now, there is a time and a place for weighing of evidence, but that is either at trial or the Rule 56 stage. It is not here. So they're asking them to just not look at the evidence. Don't look at that. Don't look at none of that. All that they submitted to you is, don't look at any of that. That's not the time. There's a time and a place, but this ain't it. Now I need a lawyer to break that down for me, because it really sounds dumb to not look at the evidence. But I don't know, because I don't know the way these events are taken, the order of events. It is not here. And UMG has no answer whatsoever to the binding Second Circuit authority that we cite at page 14 of our brief, which is the Global Network Communications case, in which the Second Circuit makes clear that the conversion requirement of Rule 12B is mandatory, not discretionary, And under that rule, okay, wait, the court just cut him off again. The court cut him off again. And under that rule, the rule allows me to, Rule 201 allows me to take judicial notice at any stage of the proceedings. That's explicit in the rule. And certainly ample cases take judicial notice into context of a motion to dismiss. That doesn't convert into a summary judgment motion. By definition, it doesn't, because I am permitted to consider both materials within the four corners of the complaint. Matters that are incorporated by reference or that are integral to the complaint, and facts that are judicially noticed through Rule 201. And if I do, then that doesn't convert it to a summary judgment motion. That's what it sounded like she wanted to say. They cut him off. Mr. Gottlieb, that's correct, Your Honor. We don't dispute that. What we dispute is UMG's suggestion that the court can either use the materials for either the truth of the matter asserted, which they're disclaiming here, but also can use the materials to make factual inferences based on the content of what the court finds within those exhibits. The court, well, you can hear the pettiness. Well, let's just talk about the song lyrics in the rap battle. There's an argument that there's already incorporated by reference, except perhaps one, the tailor-made freestyle, which was notably omitted. Y'all left that out. It's notably omitted. Okay, y'all took that out. Okay, notably omitted in the amended complaint by reference. But the other songs in the rap battle are referenced and linked to their Spotify, or I think it was their Spotify listing. So I'm not even sure that I need to take judicial reference that they're not incorporated by reference into the complaint. But certainly there can't be dispute about what the lyrics are. The lyrics are what they are. Shout out to Mrs. Carmen for the 10. Thank you so much. When the judge compared the battle to a verbal argument, meaning the songs were like a conversation between Drake and K-Dot, so you can't isolate or separate Not Like Us from the conversation, I was like, boom. Shout out to you for the 10. Thank you so much, Mrs. Carmen. Thank you for your support. How many likes we got in the stream? 372, almost 800 people watching. Let's get, can we get to 500 likes in the stream chat? I appreciate y'all. Thank you, thank you, thank you. Let me get a sip. We are, page 30. Let's go. Over halfway done, chat. Over halfway done. I love this. I like this. And I'm not gonna lie, I don't read a lot of books, so I feel like this get the mind going a little bit. I get a chance to read something. I'm excited by it. Let's get it. I don't read a lot of books anymore. I used to listen to audiobooks a lot while I was running this stuff, but I stopped doing that. I got to get back into that. Give me a book recommendation. Somebody give me a book recommendation. All right, Mr. Gottlieb. So to make this easy, I don't like that. Ooh, I don't like that. I don't like that. So to make this easy for you, since you having trouble keeping up. So to make this easy, we don't challenge that the court can take notice of the fact that lyrics exist in a song out in the world. Okay. The question is how one interprets those lyrics and what meaning is given to those lyrics in the context of evaluating the rap battle. Okay. Similarly, of course, we don't challenge that there was a rap battle. All right. We plead that in our complaint. Okay. Just listen to me. What we take issue with is UMG using lyrics to draw inferences about what reasonable listeners and reasonable viewers would have understood about the song in question. That is where the argument strays from what is permissible under the court's judicial notice authority. And it also strays. The court, stop. Stop. Once the lyrics are in evidence, then of course I can draw inferences from them. They're in evidence. They've been judicially noticed. The lyrics exist. They have meaning. They have meaning that they have. their words, and I don't understand your argument that I could take judicial notice of a song lyric, but I'm not allowed to consider what the lyrics mean. Excuse me? Sai Kazama, what up? Oh, let me read that again. And I don't understand your argument that I could take judicial notice of a song lyric, but I'm not allowed to consider what the lyric means or says? Huh? Judge is cooking right now. Stop. Mr. Gottlieb. Because at the pleading stage, the court is not allowed to make inferences against the plaintiff. The court is required to draw all reasonable factual inferences in plaintiff's favor, and the court's not allowed to take materials from outside of the complaint and use it to discredit or undermine or question the allegations that have been plausibly alleged in the complaint. And I think this argument around context this is an important example. So, for example, we have alleged throughout the complaint that the appropriate context for the understanding of the lyrics, the cover art, the video, the song are. We have alleged that the full context includes the lyrics of the song, the cover art, and the video. And we have explained in numerous allegations throughout why a reasonable listener or reader or observer would have interpreted those songs as conveying a singular and precise factual message that Drake and false message that Drake is a PDF. The court. But isn't that a legal argument that I don't have to draw an inference in your favor? Because whether a reasonable listener would have drawn that inference is a question of law, which you've already agreed is a question of law. And legal assertions on arguments made in a pleading do not have to be credited by the court, Jack. That's everything, the ending of it sounds like she'd be like, are you kidding me? Mr. Gottlieb. The question, though, is not what a reasonable listener would have interpreted the lyrics to mean. The question is whether a reasonable listener could have interpreted the lyrics to mean. In other words, is it reasonably susceptible to a defamatory connotation? Is it defamatory based? Is it reasonably acceptable to be seen as defamatory? That's the Davis standard, and we think that we have more than adequately alleged that. But more to the point, we have specific factual allegations in the complaint that UMG engaged in a coordinated, covert, and unlawful scheme to remove Not Like Us from the rap subgenre and turn it into a de facto national anthem. Oh my God. UMG turned it into a national anthem? UMG did that? Okay. That's alleged at paragraph 10 and 11 and 128 through 202 of our complaint. The complaint alleges facts showing that UMG wanted to and succeeded in making the song culturally ubiquitous. And this means that the audience, to answer one of the court's questions to my friend, the audience by which to evaluate defamatory meaning in this case is not the people who would be dialed in to every back and forth between Kendrick Lamar and Drake in the rap battle, but the audience is everyone exposed to the lyrics and imagery, not just those sort of there in their moment. Okay, we cite the Lindell versus Mayo media case in the Second Circuit that stands for that proposition. This is particularly important because we also allege with specific numbers that this song achieved a cultural ubiquity unlike any other hip hop song in history. Why does it sound like every time they speak, they bigging up Kendrick? Like the Gottlieb side is of the Drake side is literally bigging them up. Like, bro, y'all turned this into a national anthem. This became a cultural ubiquity unlike any other hip hop song in history. I guess it's to present it as something that's truly grand, which it was. Not just unlike the song, not just unlike the other songs in the rap battle, but unlike any other song in history. More than 9 billion streams at the time of the filing of our last brief have been 9 billion times have been streamed on this song. Every other track in this rap battle pales in comparison. So that relevant audience member, if the court is trying to understand an objective listener, objective viewer cannot be the person who listens to every single track in the rap battle. The relevant person is probably your average 13. Why they pick a 13-year-old though? Why they pick 13? Why they pick 13? Dancing to the song at a bar mitzvah. So you pick a 13-year-old dancing at a bar mitzvah as probably your average 13-year-old dancing at a bar mitzvah. They wouldn't be dancing to Not Like Us. Are you serious? You got to use better examples, bro. You got to use better examples. Who may not have heard any of these other songs before or may not even be that much of a rap fan. The court. That would be a very... Yes, sir! That's literally what I was thinking, bro. That would be a very interesting bar mitzvah that played that song. Mr. Gottlieb, that is apparently a very popular bar at bar mitzvahs, Your Honor. They turning their back on them? No way. Chill out. The court, I'll take your word for it. Oh my God. Let me get a sip. Mr. Gottlieb, there's a separate set of factual allegations in the complaint that add to this that UMG also doesn't add, and that's contained at paragraph 90 through 92 of the complaint. We allege that in sort of the modern social media environment, allegations of PDF are of the far more relevant social context, and whatever might have been true when Judge Daniels was considering these issues is in terrain today, given the massive global audience for this song, that it reached the entire world, and the social media environment in which allegations of PDF land today, audiences are simultaneously primed to believe and primed to react with outrage to allegations of harming children. And that is a direct response to many of the generalizations contained in the cases that UMG cited and many of the arguments they're making. These are specific allegations at paragraph 90 to 92 of our complaint. UMG is asking you, based on their sort of own spin of exhibits, to disregard these well-pleaded factual allegations. Shout out to Shane. In the complaint, how sort of the world today receives these type of allegations, and we just don't think that can possibly be appropriate at the motion to dismiss phase. Shout out to, what we got? Shout out to Cardenas for the 10 bars at the bar mitzvah. Shout out to Lawbreeze Ego for the 5. New poll. 1, I suck. 2, SAI is a bot and I still... Okay. Shout out to Lawbreeze Ego for the 5. I appreciate you, man. All right. Back to it. The court. Let me go back, because we were addressing the very inferences that could be drawn from the lyrics. And one question I have for you is, do I have to draw an inference from the lyrics? Don't they speak plainly? So for example, let's go back to the tailor-made freestyle lyric. All right, so let's run it back real quick. Let's run it back. So for example, let's go back to the tailor-made freestyle lyric, which is, talk about them like girls, that's a gift from me. And then the context with the AI voice of Tupac, it's clear. Yo, and in context with the AI voice of Tupac, it's clearly One can clearly read it to be a goad from Drake to Kendrick as part of their back and forth in the rap battle to bring up rumors regarding PDF and Drake. I don't know how else one could logically read that. If you have an alternate reading, I'd like to hear it. But I don't think I have to draw an extreme inference to understand what that line is. Well, Your Honor, the court. Shut up, I'm talking. What would be the inference that would be favorable to the plaintiff of that line, other than the one that I've just put forward? Barbie G for the 5. I bet the judge jams Not Like Us in their chambers. Bro, could you imagine? Could you imagine a meeting in the chambers, but she got Not Like Us playing? What would be the inference that would be favorable to the plaintiff of that line, other than the one that I've just put forward? Thank you for the 5 too. I appreciate you. Mr. Gottlieb, because, Your Honor, you would have to consider, as Mr. Ransom says, black letter law and opinion doctrine. You don't slice out a single line or a single statement from a song in order to ascertain its meaning. Duh. You consider the entire song and the entire lyrics in context, the court. But I'm asking you about this line in this song. How would I read it? You said I can't draw inferences from these song lyrics. I can just consider their existence. But do I have to draw an inference? Yes, the words, the court. The words are the words, says the judge. Talk about them like in Young Girls. How else would I read that? Oh! The cooking continues. The cooking, the flambeing, the grilling continues. Mr. Gottlieb, Your Honor, I don't understand what legal relevance that has to the question of how reasonable audience members would have understood the lyrics and Not Like Us. Before you even get to talking about the lyrics in this prior song, you would have to come to the conclusion that your average listener to Not Like Us came into the song with that lyric in mind, had heard that song, had been exposed to it, had understood the lyrics in the same way that your Honor is reading them. And there's simply no basis on which to make that determination at the pleading stage in this case. They may come forward with evidence. The court, shut up. Let me talk. Let me have you pause right there, says the court. I understand that a lot of these cases arise in a very traditional context of a newspaper article or an op-ed or a single communication. But here, I feel like Denzel is saying this, but here, we have songs that are in communication with each other, a dialogue with one another. One artist releases a song, a few hours later, another song is released that responds to that song and back and forth. That is the context in which these lyrics arise. So to take Not Like Us as the specific example and just isolate it, isn't that taking it out of the broader context in which it existed? It would almost be like taking a single paragraph out of an op-ed and not looking at the headlines and the remainder of the article, because you can't look at Not Like Us in isolation. It's a response to what came before it. Oh my God. It is a response to what came before it. Okay? Mr. Gottlieb, so Your Honor, we're not advocating for the court not to consider the context that this song was the penultimate track in the rap battle. That's not our argument. Our argument is the song in particular, both in this rap battle and in the history of music, is different. Holy sh! This song is different. And this is an honest question I want to ask to everybody. The song is fire. And is now considered the greatest diss track of all time. But is it different? Or is what being said in the song just so fire that it is what it is. It's just a dope song. But is it different than a diss track? Any other diss track? Like I said in other diss tracks, bro, like, that's why I choke, you fat mother. Get money. You know what I'm saying? Like, come on. I don't know, bro. I don't know. Where am I at? It was different in the fact that it was immediately understood in the allegations of our complaint to contain a precise factual allegation and a single factual allegation. The false allegations that Drake is a PDF, we allege. The court, let me cut you off. Let me stop you right there. At the time Kendrick Lamar released this song, there was no ubiquity. And there was obviously, he's not a fortune teller. He wasn't going to understand that at the moment that he released this song. It was going to have 8 to 9 billion streams, and he would be singing it at the Super Bowl. He was releasing it as a part of his back and forth that occurred over the matter of days. And isn't that the context in which I need to understand that assertions made? Not 6 months later that millions and billions of people have now listened to it and they may not have that understanding. But at the time the statement was made, it was in direct response. And let me give you a hypothetical. If two people are arguing on the street and throwing insults back and forth, and then later one of them says, okay, that particular statement was slander. You defamed me. I'd have to know what the interchange between the two of the individuals were that were throwing insults to understand the full context in which whatever statement was made. Shout out to who that was the donation you made talking about this specific portion here about the argument. Thank you for that. Lawbreeze ego, like my daddy used to say, mustard. Shout out to you for the 2. Isn't that comparable here? Someone insults, the other person responds with further insults. The other person responds with other insults. How can I just take one of these songs in isolation and apply a completely different standard to it? Because 3 months later, billions of people have now listened to it. Oh my God. Oh my God. Cooking. Mr. Gottlieb, Your Honor, I appreciate that question. I think it stems from a lack of grappling with the and perhaps due to the imprecise briefing on our part, the role that Republication plays in this case. We have alleged in our complaint, I believe in 11 separate paragraphs in the amended complaint, that UMG was responsible for the republication of the defamatory material. So we're not mad that the song is out. We mad that they publicized it at the Super Bowl? That's the issue, huh? I need more water. J2, what up? That's paragraphs 13, 21, 120, 121, 157, 191, 192, 232, 241, 246, and 266. The standard for republication is that a defamatory statement is republished whenever it is intended to and actually reaches a new audience. That's the New York Court of Appeals decision in Firth v. State. We allege this throughout our complaint. UMG said nothing about it until their reply brief in this case. So we have alleged that UMG took steps at multiple times post-May to republish the material and introduce it to new audiences each time it did that, it was liable for that republication. And each time it did that, its knowledge at that point in time becomes irrelevant. And we have pleaded that knowledge in the complaint, including what it knew in July, what it knew in August, based on retraction demand letters that was sent to it. Oh my God, I keep forgetting. They was sending retraction letters to get this song to not be played at the Grammys and not be played at the Super Bowl. What it knew when it launched the Super Bowl campaign. But even if you don't agree with us on that, we allege in the complaint before you get to republication that the defamatory material includes the song, the cover art, both of which were released on May 4th, and the video was not released until July, 2 months after release of the song. And UMG's knowledge at that time that it released the video included all of the information that we have alleged in the complaint, including the attacks on Drake's home in Toronto. 3 separate attacks on his home in Toronto, the attack on his OVO business in London, the fact that users all over the United States were commenting on him being a PDF, and the fact that Drake had denied factually the allegations in the Heart Part 6. We make all of those allegations in the complaint about UMG's knowledge at the time of the publication of the video. So that's the latest point. That's the earliest or the latest. But their knowledge clearly at the July point in time, before you even start talking about liability for republication, comes into play. And then, Your Honor, with respect to your question before about sort of removing the song from the factual context of the battle, and doesn't it sort of have to be understood that way? We have alleged that this song was actually understood as a sort of singular entity because of its cultural ubiquity. Oh my God. No, this is a part of all the other songs. And if you would, and here's another thing. Oh, who is that? Who just gifted some memberships? Shout out to Lawbreeze Ego for the membership gift. Audiobook, if you choose Dungeon Crawler, Carl. Shout out to Spike for World. Appreciate you on that. Thank you for gifting that membership. If you guys want to become a member, man, you can do that by hitting the link in the comments, man. Thank you for doing that. I appreciate you. Where am I at? So, for example, UMG has Exhibit P, which is a podcast transcript that we cite a piece of in the amended complaint. At pages 4 of that podcast transcript, there is a discussion about how Kendrick is making allegations about Drake. Some of these things have been fact-checked, and then later on down, one of the commentators says, I don't know if there's ever been a time when a rap superstar or 2 rap superstars are contemporaries and one is accusing the other of PDF, excuse me, like in the loudest possible way. It continues, contemporaries, people who are making their record label billions of dollars, right? That doesn't usually happen. And this level of allegation, maybe it should inspire some sort of investigation. Later on, page 5, it says that one of the commentators says it's unclear right now if the claims of Kendrick Lamar's domestic abuse are true. But let's talk more about these allegations around Drake. No one has previously called out Drake in this way. Is this the Joe Budden podcast? Now it's being raised to a more mainstream conversation because it's a hit that Kendrick is making. Your Honor, Exhibit B to UMG's request for judicial notice on page 10. The commentators describe Kendrick Lamar in the song as indicting Drake for years of rumors and speculation. Indicting meaning a specific factual charge being made in a song based on rumors and speculation. Notably, Not Like Us doesn't include the rumors and speculation in it. It doesn't talk about any of the underlying rumors that Mr. Ransom was talking about that Drake allegedly had to deal with in the past. It only includes the indictment, the specific charge that he is a certified PDF, the cover art, which is his actual Toronto home, which, by the way, is also validated by the other exhibit that UMG wants you to take notice of, Exhibit J. Page 4 describes the content of the song as a sex offense allegation. Throughout Not Like Us, Kendrick accuses Drake of having inappropriate sexual relationships with minors. This is also a topic Drake has had to debunk in the past. However, Kendrick doesn't shy away from the blowing up the rumors surrounding Drake's personal life with his lyrics. Later down, the Predator accusation includes the cover art for the track. In fact, an aerial picture of Drake's mansion allegedly dotted with sex offender location tags. These are their exhibits from commentators interpreting? Interpreting? Is that a word? Is interpreting or interpretating? Is interpreting a word? Interpreting the lyrics of the song contemporaneously. I'm sorry. Understanding it with the precise meaning that be fact checked, that can be proven true or false. So if these things are in the record, we're fine with it because they all prove that there is a susceptible connotation that can be drawn that the song had a precise meaning. Your Honor, I don't know if the court stopped right there. Let me ask you this. Your client also in the course of this rap battle leveled accusations against Mr. Lamar as well, that he's not the biological father of his children, that he beats his girlfriend. Are those facts or opinion? Mr. Gottlieb, are those, I'm sorry, Your Honor, the court, are they fact or opinion, those lyrics? Mr. Gottlieb, I don't know that the court has a record sufficient to be able to make that determination because the court doesn't have the context behind all of the different allegations in the song. There isn't a complaint with 250 allegations giving meaning to the lyrics. We don't know. Was there cover art? We don't know. Was there a video? We don't know. Was there a singular message? We don't know how people understood it. So that is both a determination that the court doesn't need to make here, nor is there one that the court has a record to make here. That could be the subject of questions that I imagine UMG will want to get into the discovery in this case. But it is certainly not a reason to find that the pleadings fail to state a claim on which relief can be granted. I don't know if the court wants me to address the actual malice arguments that have been made. The court, I do not need to hear arguments on actual malice. Okay. Real quick. Shout out to the 490 likes in the stream. Hit that like button. I appreciate you. Almost at 500 likes in the stream. Thank you guys so much. Also, having existed in hip hop for 15 years, to love the sport is to invest in it, then try to gentrify the genre when he loses proves he's never been like us. Oh, I do got more water. Chat, we almost done. We got less than 10 pages, 42 pages in. Thank y'all for sticking with your boy. Hit that like button and subscribe to the channel, man. I appreciate you. Almost at 40K. Almost at 40K. Sure. So with respect to the Section 349 claim, Your Honor, Mr. Ransom made essentially two arguments. The first is he made an argument about information and belief pleading, and the second is about the injury element. So let me address the information and belief pleading. I think this argument just simply misunderstands the nature of the allegations that we make in the complaint. And so we don't think it actually matters whether the court concludes what the standard of information and belief pleading is. Even under the standard that UMG articulates, we believe our allegations meet that for the purposes of Section 349. So we essentially made four arguments that support the underpinning factual allegations of materiality and consumer harm under Section 349. The first argument we've made is that UMG misled streaming consumers by paying or by causing payments to be made to third parties to have bots artificially stream recording on Spotify to boost streaming numbers. And that's paragraph 173 to 178 of the amended complaint. Now, UMG says that this is based on information and belief, but the standard here is plausibility under Iqbal and Twombly. Excuse me if I said that wrong. And we more than meet that standard for the following reasons. So under paragraph 174, we allege that fake streams are a huge problem in the music industry and that UMG hasn't disputed that up to 10% of all music streams are false. And in 2021 alone, 1 to 3 billion fake streams across popular music platforms were fraudulent. If that's the only allegation we have, we agree we'd be in a bad place on information and belief pleading. But we continue that in paragraph 175, fake and manipulated streams are significant problems for Spotify, which invests heavily in their reviews on it. it is a reasonable inference that Spotify would not make heavy investments in a non-existing problem. We also allege that Not Like Us sets records on numerous streaming platforms. It was the fastest song to ever reach 300 million Spotify streams in just 35 days, which is paragraph 130. And one possible inference of this, which we believe the court must draw at this stage, is that the unprecedented rocketing up of the streaming chart that UMG was using a technique that is evidently used on 10% of all music streams to manipulate stream totals. Okay. Now UMG does not dispute any of the paragraphs from paragraphs 129 to 171, addressing its completely unusual and unprecedented tactics in promoting the popularity of Not Like Us. That includes things like whitelisting agreements with other parties. Whitelisting agreements with other parties. I'm not whitelisted, so all of my videos still get flagged, so I don't know what they're talking about. All of these allegations I just referenced are the background for the pleadings for the allegation that UMG describes as information and belief. That background supplies the context for paragraph 176 to 178, which are based on three things. One, a popular podcast host who insists that he knew that Not Like Us used bots. Oh my God. Here we go with ACK. Second, are users on social media claiming to be music industry whistleblowers who witnessed the buying of promotion through a digital marketer. Isn't that bro that was on his channel? And third, that's already been debunked. And third, a self-proclaimed retired stream farmer who posted a video in which he claimed to show how a streaming bot had UMG and Kendrick Lamar used to boost Not Like Us streams and their beef with Drake. What does that say for the current standing, bro? What does that say for the, like, people are still listening to the song. Now, it's probably not getting streamed as much, but the streams are still going to be streaming, bro. They just going to keep paying for it to keep boosting the numbers. These are individuals who purport to have firsthand knowledge. They're included in our complaint, and they are all consistent with the underlying and background allegations that preceded. This is an entirely appropriate allegation on information and belief. And under the authority we've cited, these are particularly appropriate information and belief allegations when you are dealing with a covert scheme, where in order to complete our proof of the claim, we rely upon evidence that is in the possession of the defendant, that is in the authority that we cited. We also, which also cites cases from the Second Circuit at this point. On this point. We make three other arguments on this that I'll only mention very briefly. The second is that UMG provided financial incentives to streaming platforms to promote the recording and recommendations playlists and search results. And in particular, this is important because it relates to the injury argument, which I'm about to get to. We allege that UMG charged lower than usual license rates in order for Spotify to recommend Not Like Us. And we allege in paragraphs 180 to 183 numerous examples of users who describe searching for other. Oh my God. We have talked about this so much, bro. We talk about this so much and it's been debunked. We did it live on stream, including searching for Drake's music and being directed to Not Like Us, both on Spotify's platform and on the Apple platform. That's quite important in the injury allegation, which we've also talked about because Drake's being mentioned in the song so much. Whenever you search Drake, it was probably going to some of that because his name was mentioned. Shout out to Mrs. Carmen. I love that you're reading the transcript so fans on either side can't spin it. Don't make me call you a journalist taking academics title. Shout out to you. Thank you so much, Mrs. Carmen. All right. The last two allegations in this are the pay-for-play payola allegations in paragraph 184 to 188 of the complaint and misleading statements that UMG made about the recording, streaming, and radio success. While knowing that such success was inflated by its deceptive scheme, and that paragraphs 130, 154 to 155 and 257 of the amended complaint, all of that is entirely appropriate under any pleading standard when considered in context. The second argument that Mr. Ransom made was about the injury element. Mr. Ransom argues that the injury is too attenuated. Excuse me, hopefully I said that right. Attenuated. There are too many steps in between Drake's suffering harm and the alleged harm to consumers. That's simply not the case. So as I just explained, as we've alleged in paragraph 180 and 183, the scheme that we have alleged misdirected consumers away from Drake's music as a result of manipulation of the search functions on Spotify and Apple. I think that's just a natural occurrence. I think it's just a natural occurrence. Or unless it was the first time somebody else has been mentioned so much in another song that it led you to something else. I think that's like SEO, bro. I think that's just how it works. And the result is that consumers were misled into streaming Not Like Us rather than Drake's music. We have also alleged that this caused direct financial harm to Drake, not indirect financial harm to Drake. In paragraph 229 of the complaint, where we explain that reduced streaming rates translates into reduced royalties. So before you get to any argument about the court stops you, can you just explain to me, and I'll express some ignorance as to how whatever algorithm applies to Apple Music and Spotify work? But how is this either the streaming bots or the pay-for-play related to the notion that if one went on Spotify and tried to play Drake's music, you'd be redirected to Not Like Us? The connection between those two things is not entirely clear to me, and perhaps is because of my lack of familiarity with how these platforms work. Mr. Gottlieb. So the streaming and bot farm is distinct from that claim, Your Honor. The streaming and the streaming fraud allegation was sort of the first set of allegations I listed out. The payment of financial incentives to promote the record and recommendations in playlists and in search results was the second. Those are contained in separate allegations in the complaint. And the allegations there is that the court. So then what is the inquiry with the respect to the bot streaming allegations? What would Drake's injury be? The injury in bot streaming is that there is a dilution argument. And there is a sort of streaming to get streaming argument. So the dilution argument is the larger number of fake streams that exist on a platform and the lower the royalty rate that goes to the artists that are not involved in streaming. The court. So what you're saying is every single artist on Spotify would have this exact same cause of action against UMG. Yes, says Mr. Gottlieb. And that's entirely consistent with section 349. In the Northern Autobahn case that we cite in our papers, there's two cases that cite in our papers on the inquiry requirement, recognizing that by giving any person is the language of section 349, by giving any person who is aggrieved by an injury to a consumer standing under section 349, there's potentially a large number of businesses, particularly in the competitive situations, that can bring claims. But the court has held that was the intent of section 349. If you give me 1 minute, Your Honor, I'll get the case so I can make sure I cite it correctly. Sure. Whenever somebody says sure, they don't want to hear what you're talking about. Okay? Sure. Mr. Gottlieb, it's the North Shore Autobahn versus Progressive Insurance case from 2012, and it explains in the section on direct injury how the statute allows for any person to bring a claim, and the question is whether the business that is asserting the claim suffered an injury as a result of the consumer deception. The claim in the North Shore Autobahn case, as well as in the MVB collision case that we cite, was essentially that the consumers have been deceived or misled by insurance companies in a scheme to take their business to other businesses that happen to be competitors. And as a result of those consumers being misled to go to other businesses, North Shore Autobahn suffered harm as a result of having less foot traffic or less traffic into the business. That's essentially the argument that we're making here. When consumers were misled into consumers are misled into listening to a song when they're searching for Drake's music, he is injured both directly, but he is also injured as a result of dilution, because the less compensation that occurs in the formula from Spotify for its artists. Your Honor, with respect to civil harassment, we can rest on our papers and the authorities cited therein, unless the court has questions for me. The court, that would be great. Thank you, Mr. Ransom. I'll give you a brief period for rebuttal. Mr. Ransom, thank you very much, Your Honor. I will endeavor to be brief. I'm sure you will hold me to it. Let me start, if I could, with Exhibit B, J, and P. To our request for judicial notice, those again are articles that are cited in Drake's complaint. And if I heard Mr. Gottlieb correctly, after discussing them, he said these things in record. If the court wants to consider them, I think this is a quote, "We are fine with it." So I believe that addresses in large part one of the court's first questions as to whether and how it can consider these materials that have been submitted. I believe he said the same as to the song lyrics. 3 pages left, chat. Run it up. 3 pages left. Let's get 600 likes on the stream. When I look, for example, at Exhibit P, and I think about Mr. Gottlieb's characterization of it, I think it also resonates with the court's comments that if the court has these materials in front of it, it can look at them and can look at the entirety of them. So Mr. Gottlieb invoked in Exhibit P the statement, and some of these things have been fact-checked, suggesting that tended to convey a finding of fact versus opinion. That court cuts you off. Page 4 of Exhibit P. Let me go to that. Hold on real quick. I'm here. Mr. Ransom. This is the page. This is page 4 of Exhibit P. And he quoted solely on the portion that some of these things have been fact-checked. He failed to read the rest. This illustrates why context is so important. It says, and some of these things have been fact-checked, like Baka Not Nice, who's a rapper in Drake's crew who was convicted of assaulting a young woman and who was accused of running a prostitution ring. That's the fact-checked reference. He also overlooks the fact that this article, which they're fine with the court considering, in talking about Drake and in talking about the references and Not Like Us, say things like, these are the speaker's quote. Excuse me. Where's I at? These are the speaker's quote. We all know the stories of him going out to girls' basketball games, and it's in our faces. Let's talk more about these allegations. That's on page 4 and page 5. Let's talk more about these allegations about Drake. Terhaka, hopefully I said that right. Terhaka, as you mentioned, there are some things we've seen and heard over the years, and then it refers to discussion over the history of Millie Bobby Brown and her relationship with Drake when she was 13 and he was 30 or 31, one of the two. So these articles provide the context that the court can and should consider in our motion to dismiss. So true, with respect to the lyrics, and again, the court asked the question about tailor-made freestyle, and you're right. It is conspicuous that tailor-made freestyle is not included in the footnote in Drake's complaint, but it is referenced in these articles that Drake is fine with the court considering, and there's no real question that it's a part of the battle. And again, I think it speaks to the question of context, because yes, I focus on the line, talk about him liking young girls, that's a gift from me, from Drake. But the context of that is not even limited to that line. And Your Honor, I'm going to read it verbatim. Please excuse the profanity. This is the entirety of the statement from Drake. Kendrick, we need ya. The West Coast savior. Engraving your name in some hip hop history. If you deal with this viciously, you seem a little nervous about all that publicity. Fuck this Canadian light skin dot. We need a no debated West Coast victory, man. Call him a bitch for me. Talk about him like a young girls. That's a gift from me. That's the context in which Not Like Us appears. That's the background. That's the history, and that's what clearly conveys this rhetorical hyperbole that what you hear in these rap battles is trash talking in the extreme and is not and should not be treated as statements of fact. Very briefly, Your Honor, Mr. Gottlieb says there's no indication of dispute in Bryan as to the context of the connotation of the statements. Bryan is a New York Court of Appeals decision. I'm pretty confident there was a dispute in Bryan, and if the court looks at it, the court reflects that the parties vigorously disputed all the issues, but that context was key and that the motion to dismiss was properly granted. Mr. Gottlieb also invokes global networks, which is in their brief, albeit not for the point that he cites, and with good reason. On the pleading standard, motion to dismiss standard, global networks was effectively overruled by Twombly and Iqbal, so it doesn't actually state the correct standard. Very briefly, on the Section 349 claim, I think that the discussion with counsel illustrates is the fundamentally indirect nature of any injury or harm that Drake claims. It requires consumers doing a thing, Spotify doing a thing, royalty streams doing a thing, multiple steps, and that is not what 349 is intended for. It is not intended to permit any person who claims, in this case, as Drake does, that they were effectively indirectly impacted by some purported consumer deception to bring a claim. That would frankly flood and overwhelm the courts in a way that is unsupported by the Court of Appeals requirement that the injury be both tangible, non-speculative, and direct. The court. Thank you very much. Unless the court has questions, I will rest. The court. Thank you very much, counsel, for your arguments today. They were very helpful. The court is going to request that the parties order the transcript and split the costs among them. I'm going to reserve decision on the motion to dismiss, so an opinion will ultimately follow. Are there any other issues that the court needs to take up today? Mr. Gottlieb, none for the plaintiff, Your Honor. Mr. Ransom, no, Your Honor. Thank you very much. Very much. Court is adjourned. And we made it. Bars in the chat. And we made it. Chat, do me a favor, man. Hit that like button for your boy. That was 53 pages, 2 hours, and 11 minutes of reading. All right, now I'm going to go re-up. Now I'm going to go re-up on my coffee and get something to eat. But listen, I do believe the judge was going crazy. I'm not going to lie. I think the judge was going crazy. I think the judge really is trying to temper their decision, trying to temper their, maybe the way that they're leaning, because it seems like leaning in the favor of UMG and Kendrick and being like, but like y'all saying all of this, but this exists. We can't not forget about that. Like we can't forget about that. Yeah, I'm ready to take the SATs again. So judge was cooking in this one, man. Let me know what y'all think about it. Y'all see my voice? My voice already? I'm glad it went towards the end. Let me know what y'all think about this in the comments. Of course, as always, let me know where you guys are watching from. Let me know your opinions on this in the comments. If there's anybody who wants to try to do the timestamps for each page, if there's a specific page that people are really gravitating to and interested in looking at, feel free to post it in the comments, man. I love y'all so much. That's gonna be the last one for me today. You'll probably see a video or two from me tomorrow. So if you guys have a chance, make sure you guys check that out. Shout out to Fully Myself for the $20 donation. You say bars, but it sounds like you're ready to pass the bar. I am. My boy Will for the 37-month re-up, man. Leonardo Thomas for the 10. Thank you. Hey, thank you guys so much, man. Joey dropping on August 29th. Anticipating it. He better come crazy. Lyrical and artistic. Clips and jib and hella on repeats in the whip. Likes up and likes up, y'all. Get the likes up. Thank y'all so much. Don't forget to hit that sub button for me, man. We're real close to 40,000, man. I really need your guys' help to get there. Thank y'all so much. I love you. I hope you have a good rest of your day. Like I said, you'll probably see some videos from me tomorrow, so make sure y'all tap in with those. And I will see y'all in the next one. I'm out. Peace. I'm going to go see Weapons, so I gotta get up out of here. Peace.